Dean's loved ones, welcome to episode 7 of the Divergence on the Fly Live Wisdom School. Today, I would actually like to speak to you from a black screen for a moment, basically to illustrate a point. I find it maybe it would be practical or practicable to share everything I'm doing, show you the documents, etc., from a black screen. You see how this actually is a little bit detrimental to your ability to see and absorb what we're trying to do here? How am I going to share documents with you if I'm on a black screen, right? So thank you to Ravina and the Queens here for always trying to, have our loved ones present themselves so that I can see them. I need to be able to see you. There's a spiritual connection here, loved ones, that energetically that I operate from all the time. So again, if I can't develop that connection with you, if I can't develop a rapport with you, if I can't actually feel you, something gets lost in translation. I don't perform the same way I, should or could or ought to. So I'm not going to call it a disrespect thing, but you know what? I would love to see your face. I would love to look at your eyes and see your vibe, see where you're at with all this stuff. That's just how I like to do it. If this constantly is problematic for some loved ones, again, we urge that you can, take appropriate steps, do whatever you got to do. If it's your device, if it's your something, if it's your other, do whatever you got to do so that I can see you. Again, this is important to me. And given the nature and the gravity of the things I'm trying to, basically gift to you, I would hope that you would just embellish me for this just for a moment. So without further ado, I would like to suggest also here that the housekeepers, the queens in the background that are maintaining and monitoring and looking after all this stuff. It's a lot of work in the background that goes on that many people aren't really, too familiar with and can appreciate fully. So consider it like this. When you're in the chats and you're speaking to the queens one-off, can we just exercise a little bit more tact and class? Can you imagine if you're always leaving a messy hotel room for your room keeper, right? Every day you're just leaving such a disgrace for her to clean up. At some point, she might wash the toilet with your toothbrush. So I would rather us do our best to maintain a positive environment where we're actually operating and conducting ourselves with, again, class, respect, and dignity. This is all Jedi principles. This is all coming in peace. This is all for a betterment of ourselves. I'm not picking on anybody, but if that's our vibe of our personality, let's work to change that a little bit. I try to come off and I try to show and present and teach with a kind and loving approach. To me, again, this is important. If I come across as sandpaper, how well is that going to be received by you, right? If you're constantly having to deal with abrasions, eventually you might run out of Band-Aids and say, you know what, I don't like this anymore. This isn't for me. So let's just keep our ships tight. Let's keep them, clean. Let's keep them on board with, all having the same direction, and we all should kind of appreciate our duties and respect each other's space, because again, that's another thing that's pretty important to us here. So I think at this point, if that message was well received, I am going to come to you in this fashion because it's more appropriate. This is how it should be. So Kim, if you want to take over controls here, and let's see what happens.
Perfect, thank you. So you guys will see that the Dropbox link has been added in the chat. Now, we do know that if you're on a phone, it makes your screen go black. So I would recommend you either join a few minutes early or you stay after class. Those few moments, you can still download it. We've also added the link to our Telegram, Dï5 Live Telegram group. So please join. Also, we do know, like I said, it will make your screen go dark, and we've covered this multiple times. So please do so afterwards, or we will have to take action, but thank you very much.
Okay, so I think we're going to tear right into part 7 here. This one is titled the interrogatory part, or if you are familiar with the KGB or the FBI or the CIA, they would call this the interrogating part. What this is lending credence to is the manner in which we are presenting questions to the court. So an interrogatory, or a session of interrogation, is literally us presenting these specific questions. Now, can you imagine bringing a court case or a claim where the defendant's name is Jane and John Doe? So I got questions, Your Honor, for Jane and John Doe, and here they are. Blah. How is Jane and John Doe going to respond? You see how that's impossible? They don't. So here's how the court system works. If no one can appear to answer or rebut or disclaim or discredit or question or otherwise bounce your case, guess what happens at the end of it? The judge is left no other option but to grant the reliefs you're seeking. So again, this is kind of a little sneaky little trick that can be done where we don't actually have to name a party. However, with a little bit of guidance and discretion and a little bit of intuition, we can name a defendant, as I was mentioning yesterday. Okay, so we actually have options. And that's the silly thing. This is why there's no excuse for us not to be doing this stuff, loved ones, is because we're literally drowning in remedy. We got so many options. We got so much available to us. And when we choose not to exercise anything, when we don't try to protect our civilian due process protections, when we don't try to enforce any type of agreement or arrangement or anything, this is why the court literally shows us no mercy. Because we haven't taken the due diligence or we haven't created an inquiry as to certain events. Your Honor, I need this title to be proved. I need to know where I stand with respect to this thing, right? These are questions. This is what the court is for, to answer questions. But you got to bring these questions properly. Again, they have a pretty strict set of circumstances, guidelines, protocols, procedures, blah, 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 blah. So that, okay, why is it so strict? Well, this is why. The courts are not to be used to, hey, my neighbor, he went into my shed and he took that thing I used to cut the grass. The court is more concerned with bringing claims of substance, bringing claims that you're not just here to embarrass your neighbor or cause him grief or things of this nature. So they want to make sure that you actually have a bona fide claim. They want to make sure that your claim is sound. They want to make sure that you can have some kind of relief. Otherwise, the clerks don't let your processes through. Again, they're there as a filter for a reason. Okay. So again, an interrogatory or the interrogatory part of the bill or the petition, this is just establishing a set of questions. We're moving him into the possession of the judge so that the court can actually answer these things. Okay, so the seventh part of the bill or the petition is called the interrogatory part and is required. That doesn't say it may be. This is required by the orders of the court to be in the following particular words or to like effect. Okay, so it needs to read just like this or something incredibly similar to this. To the end, therefore, that the said defendants may, if they can, show why your petitioner should not have the relief he or she prays for, and may, upon their several corporeal oaths, and according to the best and utmost of their respective knowledge, remembrance, information, and belief, full and direct and perfect answer, make to such of the several interrogatories or questions hereinafter mentioned and set forth, as by the note hereunder written, they are respectively required to answer. That is to say, hey, defendant, whether this or that happened, whether that or this happened, right? Like, we're actually going to do these questions for a reason, and this is why. The interrogating or the interrogating part, really is the easier way to say it, part is composed of nothing more than each of the statements we made in the charging part, right? So we're literally taking that exact paragraph. It's also in the charging part. So literally now, here's where we are actually saying it again. We're repeating it twice. But instead of making a statement or an averment or an assertion, we're actually going to stage it now as a question. Your Honor, whether it is a fact or not that I'm in possession of the legal instrument or the legal title, the facts show that I'm not in possession of said instrument. And if it need to be brought to the court's attention as a question, Your Honor, is it not proper that I be granted an investigation of my title by the court? So again, we're asking questions now. We're just not making statements. These questions are important. So after the word whether, and again, you actually literally, you got to start every one of these interrogatories with the word whether. Okay, so after the word whether, any words may be added that seem appropriate. But the best regular form to adopt is this one, whether it is a fact or not, or else whether it is not true that. You see how they present these words in a weird context. Like, this is not typically how we kind of read things. So what this is doing, again, loved ones, remember, equity kind of acts in the background. It's kind of in disguise. It doesn't quite come out and say exactly what it's doing. Is kind of ambiguous a lot of times. It's like Yoda talk. it's a little bit hard to understand. You kind of got to read it a little bit and dissect it and kind of take it apart and pick it apart and go, okay, what's that actually saying? Right? Because it's there to confuse the public so that the public is literally afraid of using these things. We don't want the public being in possession of powers or abilities to do all this stuff when they're acting as lunatics and persons and invalids and wards of the state, enemies, da 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 da. So this is why it's kind of interesting the way that they've played out all this language for us. Well, again, we thought the common law and we thought that all that legislation was difficult to read. True, granted. However, equity takes it to another level where it's a different layer. It's a different type of glasses you got to put on to read all this stuff properly. So we're going to get this little sentence started to get our questions brought before the judge, right? So whether it is true or not that, as such a form does not require the statement or pretense or charge to be in any way altered, but merely added in verbatim, in continuation. All that's saying is take your exact charge or take your exact statement, your claim, just now you're going to add a little something in the front and you're going to finish it a little different, but the body of what it is you were mentioning earlier does not change. Those facts do not change. Keep it exactly worded the way you had it. Okay, so moving on. I was alluding to this the other day, and I'm just going to read this, and now you're going to start to figure out why. If Jane and John Doe are not present in the courtroom, how are they going to make this, or how are they going to establish this for the record? Here comes the questions. And if the defendants say no, how with the truth is the contrary to be made out? And how otherwise should the facts be stated or charged, or have taken place and be enforced, or otherwise, and with what expectations, if any exist? And by what other blank? And for what reason? And for what purpose? And for what other purpose? And where? And where is such? And by whose authority? And of what amount? You see how a fiction that's not actually in the courtroom, how are they going to start to answer questions like this? It's impossible. And again, the way the court has to operate in satisfaction of the litigants, it must answer these questions. So again, if you want, we can consider now, pretend that an agent or an attorney for the Attorney General's office is in court, is now facing some of these questions. So you can see why when you style these questions properly based on, hey, Your Honor, I brought all this, and if this isn't legit, if this isn't bona fide, if this isn't correct, if this isn't prudent, if this isn't the way it ought to be done, how should it be done then? So literally, you just told them, hey, you now have to give it to me exactly the way I need to do it, which literally puts you into a position of you can't fail. Either your position was strong enough or it had enough merit or validity so that the judge can act on what it is you presented, grant the relief or the decree that you're seeking, or force him to answer all this stuff. It's a win-win, okay? So any inquiry, again, a question, or any number of questions or inquiries may be used as are at all relevant and tend when answered to supply information concerning the fact stated or charged. So this is the interesting thing. We can lay out a few facts and then we can stop and then we can actually ask a question that says, hey, if this isn't it, how should it be? Now, depending on the answer from the judge or the defendant, would they not fill in a whole bunch of blanks right about there? Of course it would. So we only really need to pose half of the problem. And now as a question, we can literally sit back and wait for the answer, which would literally fill in the other half of the problem. Thereby, ta-da, relief can be granted accordingly. So in a case that maybe the defendant does deny what it is you're stating or charging, by asking after the circumstances attending it, which is another way of just simply saying, okay, once we state our facts, here comes, the questions that are surrounding it, attending to it. If not as stated or charged, the only restriction being that special inquiries, there's that word special again, must have relation only to the fact stated or charged and should not apply or suggest or tend to seek precise information concerning any important fact not already stated or charged, but should ask generally only as to what any fact in denial, if any there be, is. So this is where, again, they start to fill in the blanks for us. We don't have to come at this thing with 10 out of 10. We can literally come at it with 5.5 out of 10, 6 out of 10. Again, I strive for a little bit better than that, but for anything that we're not in quite complete understanding or we have the answers to, you structure your questions to get that filled in. So the object sought by the interrogatories or the interrogating part is to save you, the petitioner, from the necessity of having to supply evidence as much as possible. Well, that sounds favorable. Again, just enough evidence and information to get the ball rolling. It's it. We don't need a whole lot more than that. They will actually fill in the blanks. See how it's such a loaded dynamic? It's a win-win. We don't lose. So for any charge made against him, to see how he would admit to it, or if he denies any statement, pretense, or charge, to force him to state what grounds he has for such denial. If the Attorney General's office says, no, you're not entitled to this relief because there's no agreement in place with the Attorney General's office, what did he just tell you to do? This is what the Attorney General's office has already told us to do. That's why I know that's a beautiful little example to play from. So the general result, however, seems to be that defendants, of course, as we all know this and can appreciate this, most defendants deny every fact possible so that they can, with safety from detection, and only do admit such facts as seems to be stated so as to confer a benefit or to help them. So that a bill or petition must be very specious. Specious is just meaning, keep it dialed, keep it tight, keep it very focused. Don't get all lovey-dovey with all kinds of other, layers of things that we don't need to be talking about, to get any admissions or any important information from a defendant answering. So again, style your questions with particularity. Style your questions with just boom, boom, boom. Keep them short, keep them tight. Okay. Let's see. I don't have the benefit of scrolling my page forward, so I'm just going to talk for a minute. There we go. So a claim is not part of, hang on, can we go back just a little bit? A little bit more. There we go. A claim is not interrogated to, but omitted in this part, which means we can either play with this or you don't have to play with this. Again, we got the option here. I love playing with this because it's just, again, it shows more or a resolute kind of, I've done my time in the trenches. I can throw this one in the mix as well because it only helps us. It doesn't derogate or it doesn't deviate or bring any harm or fatal component to what we're trying to do. So because the stating part of the petitioner's claim is undeniable, it's evidence that he makes such a claim. And so this cannot be disputed. Again, especially when you part ways from that legal fiction and you start to attach it to another party, when you cannot be construed as acting in person, when you cannot be construed as being the debtor, how can a debtor now rebut your presumption or what it is that you're trying to lay down as evidence? See, it's impossible. It doesn't work, which is why you literally allow the judiciary to find in favor of your pleadings here very quickly. Again, in what circumstances would a short notice application made to chambers be where the judge actually doesn't even have to give notice to the opposing party? He can grant the order right now. Doesn't that sound a little bit off compared to how the court systems usually operate? Don't when you have a claim or you have a dispute or something, doesn't the other party, don't they have to be given notice? Well, yeah, they do. Well, apparently not in this case. You bring your case so tight, the judge knows, okay, there's no way another man or woman can rebut this, so put this through, grant it. Once that title's granted, or once that order or decree is granted, you can literally now go fire off, notice to the Crown as represented by the Deputy Minister of Justice, acting for the Minister of Justice or the Attorney General, blah, 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 and so it goes on. So to the end here, I'm going to read this is a working example out of Gibson's book. So what you're about to read is not a single word of mine. I know this is going to read a little bit technical. Our workings or our documents don't have to be quite reading like this again, but you have an example to work from, okay? Because I'm going to mention the word confederate here. Confederate means a person who works with, especially in something secret or illegal, like an accomplice. Now, again, our specific situation is not implying that there's illegal things going on. Well, no, because by our voluntary admissions, we create the entire legal construct. So it's going to be kind of hard for now to suggest it's illegal when we're actually doing it. So, may upon their several and restrictive corporeal oaths, full, true, and direct and perfect answers make to the best of his or her respective knowledge, information, and belief. I know some of this is a little bit repetitive from above. To all in singular the matters and things herein before stated and charged above, as fully and particularly distinctly interrogated, and that not only to the best of their knowledge and remembrance, but also to the best of their several and respective information, hearsay, and belief. Okay, well, hearsay, we're kind of led to believe like, well, that's hearsay, that doesn't apply. Wrong. What is that? What does actually the word hearsay imply? I'm here saying something. Again, maybe we were kind of misled earlier when we took a previous definition of a word. Well, there's a good example of one. So to answer and set forth a full, true, fair, and accurate account. There, we're already talking about some relief, some equitable doctrines, relief type stuff right there. So an account of each item of property, including goods and chattels, money, accounts, notes of hand, bills, single, bills of exchange, mortgages, and other evidences of debt by him or them, or either of them, received as administrators, as mentioned above. Again, when they are managing that implied trust for us, there is an administrator kind of already floating around in the background doing stuff. And again, I know this firsthand. I was in one of my first court cases way back in the day when I got about halfway through my case and it wasn't going that well at that particular time. So I literally just say to the judge, well, Your Honor, seeing as I'm the administrator of, I didn't even get the word of out of my mouth. The judge literally flies out of his chair across the bench and he's like, he almost came at me. You're not the administrator of nothing. And this judge was plain-faced. He was neutral. Prior to this, he was showing no emotion. He was very stone cold. And all of a sudden, this thing sprang out of the chair at me. So obviously, it's like, ooh, the word administrator touched a chord, right? So that told me right away, I just trespassed on someone's position without authority. I don't quite have the ability to come as the administrator yet, right? And this is what led Dean on the great administrator rabbit hole. So it is an important construct. It is an important component of what it is that we're doing here. Again, this is something that I'm seeking in the background as a third party to help others learn how to administrate their estate. But in the meantime, again, as I've mentioned, divergence would act as the administrator until you're capable. Ultimately, that's the goal here. And I don't know how long that's going to take for each and every one of you. So let's just put a layer of administrators in place that's going to help us get there. We'll talk a little bit more about that on an upcoming episode. Okay, so we've talked about property. Again, when they're talking about monies, bills, notes, chattels, you can add other forms of property in there. Personal estates and equitable interests attached to personal estates. Again, we can embellish on that a little bit, but just remember, these were not my words. I picked this right out of Gibson's book. So we're talking about accounts. We're talking about, hey, they have to come forward and they have to start testifying to some of these questions. And to whom and for what on account of the said administratorship. And your petitioner further sets forth in charges, and you could probably put averres there as well, that the said John Doe or Jane Doe have pending, and now this is where I can actually spin it. Now pretend that the Crown or the bank or somebody's coming after you for some reason. You're being sued for something. Maybe your house is being foreclosed on, okay? So just consider this wording for a moment. And your petitioner, you further sets forth in charges that, hey, the Crown or the bank has a pending application in your honor's court against me. Probably the all caps name that was in my possession. They want to foreclose on a mortgage that I created, executed to the holder of the legal interest at the time, right? When we as debtors created that mortgage, you were holding the legal interest. Let's say the mortgage is for $100,000. And you'll know, here's a nice little insert here. Again, look at every time you sign a check, loved ones, you notice that they have the amount of the check in numerology, right? They have it written in numbers, and then they also have the check written in words. So when you have $100,000 on the face of that instrument displayed twice, is it $100,000 on that check, or is it $200,000? When you do a little bit of research, you might be surprised with that answer. And that the said John Doe is unaware at this time and is without notice of your disposition of interests by the party sued for the reasons alleged. Okay, so that's saying, hey, Your Honor, I know whoever's trying to sue me, they don't have notice that I've corrected my position, I've cleaned up my standing, I have a better title, and I have a better claim to equity. So this is kind of what we're starting to lay out here through our questions to tell the judge, hey, you don't even need to regard the defendant's answer because I've already shredded it. I've already told you what I think he's going to say, and I've already taken his argument away. That's actually doing an incredible service to your claim. It's really showing the court and the judiciary that you really know what the hell's going on and that you actually know how to present these things, these findings. So moving on. So your pleading shall furnish the means to the court a better title and a better claim for equity, had by you now coming as a claimant. Otherwise, through your cross-claim, the plaintiff, right, because now you were the defendant in this case, now you're coming through a cross-claim or a counterclaim. Now you're coming as the petitioner, the plaintiff, the complainant. So you see how that leveled the field? They brought a claim, you bring a claim. That puts you in such a better position right off the hop. It just opened all kinds of doors for you, right? The defendant has a much tougher time bringing his jurisdiction into a case that some other person brought. You got to produce all kinds of stuff now to show why you're entitled to this defense. It's actually harder. You might as well just bring your own claim and don't worry about the $300 cost of filing the claim, because you're going to ask for the costs and the fees as part of your relief paid for. Hey, Your Honor, the bank has brought an action against me and now I need to take this time to correct a whole bunch of stuff. And if I feel like I'm that impoverished, I can't afford this $350, Your Honor. I literally had to go borrow it from my grandmother. So we need to deal with that. And again, the judge would be more than happy to. Costs and fees are always something the courts are always trying to decide. Again, we're not suggesting that a certain party is not entitled to be paid. No, of course not. We're not trying to get out of payment. We're just saying, hey, let the life estate pay for it. That's the whole purpose of us trying to come with this claim. If I'm not attached to debt any longer, that debt is attached to a third party. Let that party manage the debt while I enjoy the beneficial milk and honey over here. So again, these are all pretty important little criteria that actually form a pretty solid claim. Again, I've spent a lot of years trying to develop these things with many other loved ones. We've had successes and we've had a lot more failures than successes. But these are the conditions where equity requires us to getting the job done. At law, or on the common side, they have similar criteria, right? Again, the common law is basically a shadow of the equity one. That's why there is so many overlaps. That's why there is so many similarities between this, because Satan and the Caesar salad literally just copied something that was existing and they created a whole new thing. And then they tricked us to playing in it. Go be the crouton. We got a better idea here. Okay. So again, now we're talking about, okay, now we're coming as the claimant for your cross claim. And now we're here to invoke the court to grant the request for redemption of said mortgage. Remember, as the debtor, you weren't entitled to have your mortgage redeemed. You had no property rights. So how would you now come in and start pulling off some of these things? Not a chance. You have to divest that legal title off of yourself and get that dealt with, which is coming up right here. And so we're talking about this case is grounded in divesting the legal title out of the plaintiff, investing the same as undivided in the new trustees for the purposes of settlement and recovery of certain property interests. Again, we have to suggest the thing exists and that it's equitable that we're doing such. Now that we can prove the thing exists, now we can prove that we have a bona fide claim to it, or a just and proper claim to it. And now that we've established a claim to it, here's the reliefs I'm praying for. Here's the reason why the court should grant the decree or the order or the injunction, or whatever it is we're seeking as relief. Again, this is all, you see how one thing leads to another, leads to another. This is what they call an evidentiary chain of events. This is something that the chancellors and the judges sitting in vacation. What does that mean? Does that mean his ass is sitting on a beach somewhere enjoying a drink under an umbrella in the sunshine? Well, it could be, actually. But what that actually means is that the judge, or call it the Attorney General's office, is now actually acting ex officio. They're on vacation. They're not particularly serving the public in this capacity for the moment. Nope, they're on vacation from that. They have the ability to go do something else, entertain equity. I know, again, this is all these little nuances, but you know what? When you add up all these little nuances, this is what's going to make or break your claim. So I'm going to suggest that we get a little bit more familiar with some of these nuances and come in a little bit heavy and a little bit hot rather than a little bit light and a little bit diminished. We're just going to serve ourselves a lot better trying to get to where we're going, right? So we've vested the stuff in the new trustees and attached herein by declaration. In declaration, I don't know, maybe a quit claim deed and maybe a declaration of a deed of trust, etc., whatever it is you're declaring. And in support of the claimant's special affidavit and claim to be entitled to the equitable interest relating to said mortgage, note, instrument, chattel, whatever piece of paperwork the Crown or the state or whoever it is coming after you through, you're now expressing your equitable interest in it. This is a pretty important part. Again, we always left that dangling. We never expressed that interest properly. This is why the door was always left wide open so that another party can swoop in, take advantage of that, and then nail our ass to the cross as the debtor, the sinner. You go and you pay for that obligation now. And again, this is why we're trying to get our hands clean of that event. We created the event, so it seems proper that we should be able to get ourselves out of that event. So really, at the end of the day, coming with the clean hands literally is playing on this part of Scripture. Render unto Caesar that which is Caesar's, and give or provide or pledge that which is our Father's, give that back unto him or her. All that's doing is realigning your position. It is getting you into a place of deserving of mercy, grace, redemption, forgiveness, things of this accord. So what I'd like to do at this point is I'm going to open it up for a few questions. Kim, if you want to just fire a few at me.
Yes, we just had one. Point being, in viva voice scenario, not on paper, how does the judgment prosecutor distinguish between a question and a statement?
You're just the way you're going to phrase it. So you're going to suggest, Your Honor, on or about December 8th, 1972, the parents as informants of Darren Clifford were in possession of a certificate that respects a certain legal interest. Okay, so that's part of your statement. Now, Your Honor, because I'm expressing an equitable interest in said certificate, maybe registration number 1972-06- blah, 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 right? Let that one go. Now that I'm coming forth and I'm establishing an equitable interest in this certificate, whether or not it is a fact that I'm in possession of this thing, I'm still entitled to the beneficial interest in it. Correct, Your Honor? You know what he has to say right there? He's going to say, okay, how did you convey that interest, Darren? How did you transfer it? What'd you do? This is some of the questions that the judge is going to ask you. Well, Your Honor, under a private appointment within a security agreement expressed from the debtor's position made on or about such and such a date, where the terms and the conditions were, the receiver general, the attorney general, the judge, whoever it is you're talking about, were put into possession of said interest. Whether the mail actually got there or not, I don't care, Your Honor, because by viva voce, by my voice, I am assigning it, conveying it, delivering it, transferring it, transmitting it, appointing it, right here, right now. So as long as you don't get trapped with, again, right, the police, the courts, they always want us to identify with that fiction right off the bat. That is what establishes the rules of the game to come. If you could object to that, get it at least where the judge or the judiciary is going to entertain your position even slightly. Well, Your Honor, I believe that the record, or I know the record shows such and such a name, and upon diligent inquiry, I wish to inform the court there has been a disposition of interests of the parties. There's been a change of interest. And as such, Your Honor, at this point, I know equity will not aid a volunteer. Therefore, I cannot volunteer to act in person for the benefit of a corporation that I do not belong to. I may show up, or I may specially appear to be today, Your Honor, as the heir to that particular certificate. I would like to express some type of trust arrangement to have these matters dealt with privately. I would like to attach consideration. I would like to attach indemnification to any new trustees that may be appointed through that security agreement arrangement. Again, loved ones, I'm just speaking off the top of my head here, right? So once we get our heads wrapped around, make a quick statement and then state a question. Aren't I entitled to that beneficial relief, Your Honor? I know I am. Next. And then when you stated, and because on such and such a date, I did deliver that certificate to the Attorney General's office for the purpose of settlement and credit to his or her securities account. Aren't I entitled to that benefit, Your Honor? Aren't I entitled to enjoy that interest in that equitable property? Bingo. 2 more questions.
Okay, do we have to do something more to end the disabilities of non-age, or has the adverse claim taken this on to affirm we are not minors any longer?
Yeah, absolutely. Standing in the majority position means that you are of wisdom and you're of knowledge. Again, they had to put a guideline number out there or a date. Okay, so we expect by the time you're 16 or 18 or 21, you should have a little bit of knowledge. You should be able to manage your affairs a little bit here. And if you don't, again, the court can just swoop in and presume you don't and take over for you. Does the adverse claim establish this? Absolutely. We acting or having the capacity while of the age of majority, which means, yes, I'm of the age. I have the capacity to manage my own affairs. And here's why. I can duly attest or provide testimony to the veracity of any of the statements I've included herein, Your Honor. I should know. I wrote them. Of course, I can speak to this stuff. Now, again, this is part of the tricks. I've had a number of loved ones in the past where one of the first questions out of the judge's mouth is, did you write this? So what's your answer? Well, Darren pretty much wrote it, but Your Honor, I think I got the gist of it. You know what? That would actually fly, believe it or not. But be honest. You don't have to say, yes, I wrote this, because if you just admitted something like that, the judge is looking at that paperwork going, oh, well, okay, you know some shit. And now the judge is going to unleash a whack of questions that you may not be prepared for. So you're better off to do this. Your Honor, no, I did not write it, but I partook in its construction. I was a party to its evolution. I helped create it. I added this and this, and I thought this would be appropriate, Your Honor. And if this doesn't apply, then remove it. I try to but again, just be honest. If there's particular wording, if I drop a paragraph in your lap or drop it into your hands, where you're like, well, I don't have a freaking clue what this means. Ask questions. And again, this is where we can take the hardcore technical stuff and we can soften it. We can round off the edges. But I would rather start with something very hard, something very complicated and technical, and polish it until this thing shines to whatever layer or level you are at, loved ones. Again, this is something that, this is how you make it personal. This is how you make it you. Because when you put your touch on it, when you put your kiss on it, you actually have developed a relationship to it. It's in you now. You're laying in bed at night thinking, that sentence is still bugging me. What the hell am I going to do? You know, your wife is trying to give you a nudge. She wants a kiss. And you're like, no, honey, my brain's in the equity books. Leave me alone. And again, this is why a lot of this stuff, believe it or not, actually causes a lot of conflict within personal relationships. I've lost a few because of this stuff for that exact reason right there. I literally get it so absorbed into this stuff that the rest of normal life literally gets pushed off to the side. So if you don't have a spouse or a partner that sort of understands and believes and follows and has a comprehension of what it is here you're doing, that's a tough road to go down. So take preliminary steps to just say, hey, you know what, honey, sweetheart, this energy has been calling me my whole life. I didn't know what it is, but now that I'm finally hearing it, I wish to do something about, because it's actually triggering something in me, and I'm becoming very passionate about this. And if you don't feel the same way, I'm asking you to at least be somewhat open-minded to this. Ask me questions, give this a chance, because this has such a resonation, this has such a frequency to it, that I'm not going to stop. And yes, our relationship is very valuable to me, but you know what? So is this. And if you're not going to love me for better or worse, maybe our legal marriage isn't quite what I thought it was anyway, because I was acting in person and it actually doesn't really exist. But I love you, honey. Point is, work as a team. Now, this is hard because, again, I've gone through this firsthand. Mine and Dean's dad, although he was an adoptive parent, he was one of mine and Dean's biggest nemesis, biggest naysayer, biggest doubter, biggest spread poo-poo on everything Dean and I were trying to do for 20, 30 years. And after a while, that man, he basically came to resent us. He hated what Dean and I had done to the family name. Every time he would go to the grocery store, because he lived in a smaller town, again, this is back in the days there when Dean was on CBC News and CTV News every other week. He didn't have the knowledge or the wisdom to answer any of these questions. So he felt personally very attacked at this, right? So instead of trying to get out of that or come to us for what is it you guys are actually doing, he chose to turn a blind eye to it, and he dismissed it, which actually put him in a very confrontational state of being for the rest of his life until his very last days. As a matter of fact, it wasn't until his funeral that a very good friend of him and his wife came forward to me and told me that our dad had forgiven us for everything that Dean and I are doing publicly. Because again, yeah, I know we were making a big mess of stuff back in the day. My dad happened to be very good friends with a judge who had actually presided over one of Dean's cases. So you can see how this is just creating a whole mess. So if you don't have the inner strength, or if you don't have the command to pursue the truth, if you don't have the calling, be prepared for a bit of a bumpy ride. It's not going to be easy. I've lost a lot of personal friends because of this. Many of the queens, many of the other loved ones that we're dealing with here, they too are experiencing similar situations. But again, stand your ground. We have two families, right? We got the earthly family, and then we got our heavenly family. At some point, we literally have to start making a choice. And sometimes those choices hurt. And we don't enjoy hurting feelings, and we don't enjoy hurting people. But as a result of seeking the truth, sometimes this is one of the results. So just keep that one in mind. Be prepared for that. Go into conversations knowing that loved ones are going to dismiss you. They're going to call you crazy. They're going to call you worse things than that. They're not going to want to talk to you. I know that's a tough go, but scriptures and Christ has actually alluded to, hey, don't worry about that. Don't worry about the family you're about to lose, the earthly family, because there's a better one waiting for you anyway. And if you happen to lose your family here, don't worry. There's 4 times or 10 times the amount of family waiting for you. It was there to encourage us not to be attached to these earthly things, these carnal things, wealth, money, prosperity. On the public side, I know there's some scriptures in there saying something to the effect of this: the fat guy enjoying his wealth and his fame and fortune publicly, that guy's not getting into heaven. Why? Because he will choose to covet that wealth, and he will forsake the forgiveness, mercy, and blessings of the Father that were granted unto him, and he will make his choice unwisely. And that guy, that woman is literally volunteering for the lake of fire at that point, which is why we're trying to suggest, hey, this whole person thing, this whole citizenship thing, this whole coming with clean hands, this whole understanding the security interest, this whole adverse claim, this whole creating a financial asset by doing a couple of things to a certificate, this whole delivery, this whole possession, this whole future possessory interest, all these things. Again, I'm cutting the list short. I could probably go on for 100 points. These things all add up, and they do make a difference. The greater your spectrum of knowledge and capability is going to put you into a place of confidence. Ultimately, that's what we're after here, loved ones, is getting you in a position where someday you school my ass. I would love that. I would love to see people, loved ones that were here one day. They took the best I had to offer. They mixed in some other loved ones from around the world, spirits guiding them. These people have been touched by the hands of the Lord. These people now rise and they make my contributions look small. This is very important to me. This is why I spend the time that I do to try to get us into a position of that confidence. When you're convicted of a knowing, can you be convicted of a other knowing? No. Here's why. Your Honor, I believe, I know, I feel, I can assert, I can aver, I can protest, I can display conviction of what it is that I'm doing. I know I'm never going to be in possessory control or interest of that legal fiction again. I'm not going to take on that burden. And as such, I'm going to stand fast. I'm going to stand true, and I'm going to stand strong, seeking and pursuing the truth, the life, and the way. I know what's going on here, Your Honor. I've been studying this stuff for 30 days. I've been studying this stuff for 3 days. You could literally be coming into the awareness of this right now at the moment. Spirit can literally touch you, drop some of this stuff into your noggin while you're standing there in court at the moment. Here's proof. In one of Dean's sentencing hearings, the judge was saying, despite the record, despite all the submissions, despite all the evidence, despite all the conduct of the court proceeding to date, Mr. Clifford, is there anything you wish to add, you wish to amend, you wish to change in your pleadings? I will accept any evidence, any information right now. Mr. Clifford, do you got anything? And Dean, I don't want to repeat the words Dean said because they weren't all that great. He was still being combative. He was still being dismissive. He was still being rah. So again, right up until the very last moment, the judge was giving Dean an opportunity. Believe it or not, the judge said this 3 times. I was there. I remember. So all Dean said at the end of the day was, no, all I'd like to say is that I'm the owner. I'm the owner. I'm the owner. And then the judge was like, well, the court finds that the owner is going to jail. And I remember sitting there thinking, yep, again, the owner of what? If we had only had a better understanding of the titles back then, if we only had a better understanding of what we should be doing with these titles, if Dean had said, Your Honor, I'm the owner of an equitable interest that is not of the record, I'm the owner of a beneficial interest in certain particular property. Again, why do you think that you always see me using words like particular and peculiar? When you're dealing with a particular life estate, that told the judiciary you're dealing with one, yours. You're dealing with a peculiar financial asset over here. It's special. It's strange. It's not like the others. It's not necessarily public anymore. Something's happening to this one. Treat it as a little different. Put context around this stuff. Make it appear to be a little different. It only becomes different when we express that interest in it. Again, the courts and the judges are fantastic at tricking us or confusing us into admitting to being the debtor when we need to, admitting to being the beneficiary when we need to, so we can grant that beneficial interest right back to the state, thereby jumping right back into the trustee and the debtor position so that the state can have beneficial interest over our estates, trusts in the background without our awares. Again, when we had to hire a lawyer or an attorney or someone else to represent our interests on the legal side, we just told the judge, we're not capable of managing our affairs. I just admitted to being a lunatic. I just admitted to being an idiot. As a matter of fact, I remember, Carl Lentz back in the day, claim you're an idiot, claim you're an idiot, be an idiot, be an idiot. Wrong. That's the most ridiculous thing I've ever heard. Do not be the idiot. You're already deemed to be an idiot. Why do you want to double up on being an idiot? So Dean rolls into court the one day, makes a little sign, piece of paper, he folds it in half, says, I'm an idiot, and sets that right on the stand from where he's speaking from. And the judge is reading it. Okay, so Mr. Clifford is an idiot. And he had this weird energy to it where it almost was like, yeah, okay, we know that already, Dean. You don't have to keep saying that. So then Dean is trying to rely on being an idiot to not have legal liability and attachments brought onto him. You see how you just, again, thanks, Carl, for that one. Maybe Mr. Lentz was doing his best with what he had at the time. I'm going to suggest don't ever claim to be the idiot. We want to actually say, no. There's a new idiot in town. I just appointed that title to that gentleman or that lady standing right there. the crown attorney. Let that joker entertain the court. Let that sin, debt, and liability be attached to him. Let's put a fire under his feet and watch him dance for once so that I don't have to be. Okay, so the questions here are important. If you don't want to use them, don't. You don't have to include it in your bill or petition. I like it, again, as I mentioned, because again, it just displays another level of skill or another set of, hey, Your Honor, I know how I can use a question to direct this case. Believe it or not, the judge is going to appreciate your effort. Kim, we got another question or two? Or
yes, we do. So this is two questions, but they're on the same topic. So how does this apply to a new baby? How would you go about it differently? And the next question is, while a minor, we are under guardianship, and this continues until we come forward as man or woman in majority. So how do those two kind of blend together?
Okay, so the baby situation, the condition of the father follows the offspring. When dad's a debtor and he registers an event, it's presumed by the system and the court that baby is also going to take on that debtorship position. That's just presumed. Because why wouldn't it? If mom or dad knew how to fix the situation, wouldn't they have by now? Nope. And that dad or mom, maybe they're 31 years old, maybe they're 43 or whatever. They haven't expressed any capacity or interest in fixing their situation. So it's presumed that the baby's going to follow. Okay, so now baby's following in the debtorship position. He's being set up for it. But again, that certificate can be used for blessings or curses. And that happens when we start to use that certificate as identification. Typically when we're about 16 years old, we had to physically grab that certificate, identify as it, and then go make application for governmental services. That sin or that event is what sets the stage for the entire debtorship program. Mom and dad can fix this for baby at any point. Create a response to the birth certificate that you just got mailed to you. Send it back to Vital Statistics with some notices, with some declarations, with some declarations of intent, a deed of trust. Again, there's all kinds of stuff we can do at this point. What's that going to do is that's going to change the presumed position of that certificate, and it's going to get that path cleared. It's going to start to set the record straight. So now when little Johnny or Sally turns 16 years old, maybe they take that certificate that they've expressed a proper interest in. Now maybe they're going to take that and send that to the federal tax collection department and say, look, I'm not liable for this, but somebody else is. Now the tax department's going to get back to them and say, we need clarification. Would you mind sending us your original birth certificate? Okay, yeah, here you go. Boing. The adverse claim shows up. You want to know what the federal tax collectors do at this point? They start to treat you a little differently. They start to say, oh, okay, yeah, here we got a live one. And they start to put you in a different file. They start to put you in a different category. You are now in a different class of individuals. Doors and little buttons start to open and go off for you in the background. Now, again, depending on what the tax collectors are going to come back with please provide further particulars. You can say, hold on, please, for a moment. Please hold. I need to bring a court case so that I can have a judge approve everything that I'm doing here to avoid mistakes, to avoid trespassing on a party's rights. Again, Your Honor, I'm here to do equity. I'm here to seek equity. And if there's anything I can do from your instructions and directions, Your Honor, I'm going to do it. But here's enough substance. And again, loved ones, we can pull that off in 3 paragraphs. There, boom, there's our claim. Again, this is to come. So, hey, Your Honor, I got a federal tax situation over here. I need the assistance of the court to make sure that this is dealt with properly. And again, as long as you structure your questions properly, what do you think happens as a result? Guess who comes to your aid? Guess who actually can now act as your advocate? Another word for advocate is a friend. When we come with clean hands and as a friend to the crown, right? If you're no longer acting as an enemy or a belligerent or an idiot, how do you think you're going to be treated now? Do you think you're going to be treated with dignity and respect? I wish to be treated as holding a financial asset directly. That's a lot different than volunteering to be the debtor of a certain estate. That's a lot more beneficial than, presenting yourself as a fiction. Be the faction, don't be the fiction. Okay, so Kim, how did the rest of that second half of that question go?
Let me find it again. Sorry. And just so you know, you have 4 minutes before it's done. We kind of missed our 10 minutes. So do you want to talk about the aliens and equity? And
Yeah, okay, yeah, absolutely. So tonight in our kindergarten class, we have a bit of a presentation here on aliens and equity. There's a whole basket of goodies sitting here once we get our eyes and our minds and our ears wrapped around who are the aliens, where are they, and for what purpose, and how did this alienation happen, and what is it respecting, and what is it in regards to, and how does this kind of tie in with prophecy and scripture talking about aliens, and how, you know, we're all sitting on the edge of our seat right now waiting for the aliens to arrive, for good or bad. We don't know yet, right? What if they're all reptilians and they want to eat us? Well, we don't know that quite yet, right? Tune in tonight if you want to have a couple answers shed on some of this. I've done a little bit of digging, and I've had my head wrapped around this for a number of years now, and it's kind of, we're getting to a point where we can start shedding a little bit of light. So, Kim, did we get that one? I don't think I answered the second part of that question quite goodly enough.
Yes. Okay. Well, we had more. This seems to be a really hot topic around what to do with, you know, children, newborns. So I'm hoping that you guys can drop more questions in the chat. So then when we do our next Q&A, we can really hit this one out of the park. One of the questions that kind of goes after was, how do you know when you become guardian? You become guardian of your children, not the state.
Okay. As soon as you express the proper interest in it, and as soon as you have a court's approval, guess what happened? Boom. There, now you know. As soon as you have a decree made, yes, the petitioner, the plaintiff, the complainant, on such and such a day, brought a motion to the court for a hearing, and upon hearing the such, and upon hearing the statements and arguments of counsel and the complainant, the court has found the following: that the complainant does have a beneficial interest in such and such property. The plaintiff does have an entitlement to an accounting. The plaintiff complainant does or ought to have a decree awarded in their favor and for the appointment of a personal representative, or have an injunction granted in their favor. Depending, the relief prayed for literally becomes a big part of the decree that the judge is going to grant you. And again, believe it or not, loved ones, I think I've mentioned this before, we write the court order. We write the decree. It's us. The judge looks at it, approves it, or the master. Again, I'll touch on master here for a quick second. The judge approves your order. If you tell the judge, Your Honor, I'm not capable of drafting an order, he's going to look at you a little bit sideways because, okay, well, wait a minute. If you figured out how to bring your claim properly, if you knew how to state your relief properly, how the hell can you not know how to draft your order? But if you don't, the judiciary will, again, at this point, come to your aid and assistance, and they will draft it for you. But again, I love presenting these facts, this evidence, this whole direction. Hey, Your Honor, look at our level. Look at our consciousness. Look at our love. Look at our discipline. Look at our determination. And again, we get applauded for this in the background. We all have fan clubs at our local courthouses because they see us trying. Equity aids the vigilant, not someone who wants to sleep all day. The point is here, when you start coming forward, expressing this stuff, mom and dad doing it properly can start to protect the baby. We will go from being a minor to a major, or someone with beneficial standing and interest capabilities once we start expressing it. Again, remember, the court of itself will not presume a party to have a better title or a better claim for equity until you start dropping it. So this is where we have to start dropping it. And again, it doesn't need to be 40 pages. We're going to get this cut up. We're going to get this simplified. We're going to squish this. We're going to condense this. We're going to get this a lot more workable. And again, in a manner and in a fashion so that it's applicable for you. How much empathy and how much emotional connection do you loved ones actually develop with my paperwork? You see how it's kind of like a little bit scattered. It doesn't really have that same, but when it starts coming from your mind, your mouth, your hand, watch how you develop a personal relationship to this effort. And watch how your wisdom just gets launched. Watch how you start turning into a teacher. This is the best way to get really good at this stuff. Start teaching it to others. I found out the hard way that this is one of the easiest and best ways to do this. Because it's like, we get put on the spot. We don't want to appear to be unknowledgeable, or we don't want to appear to be knowing stuff, right? So something kicks in right at the last minute where it actually puts you in a position where you're able to speak this stuff a little better than you thought you could. Challenge yourself. Take advantage of others asking you questions. Do your best. And if you get hogtied and you don't know the answer, that's what the chat box is for. That's what the Queen's layer is for. That's what I'm here for, doing all these meetings. So if I see some of you loved ones tonight, fantastic. And if not, I will, because today's Friday, this is part of the other criteria that we're presenting with the live show, the Divergence live stream, the wisdom system at this time. We're taking weekends off for a little bit here. We got so much on the go, and that this is actually taking up so much of my time to provide these little 1 hour inserts. I'm going to need to take the weekends off for just a little bit more here to help others in the background get the other stuff rocking and rolling. And as a collective effort, we're all going to get to where we need to go sooner, faster. Okay. So this is me signing out, loved ones. Look forward to seeing you on Monday, same time, same place. And again, drop as many questions at us as you can, because this is fuel for our fire. Okay. Love you all.